This Honorable Court of Criminal Appeals of Tennessee is now in session.
Thank you. This is afternoon session for the second day of the February term of the court here in East Tennessee. The panel consisting today of Judge Robert Holloway to my right, and from Columbia, Judge Robert H. Montgomery to my left from Kingsport. I'm Kerwood Witt, and I live down in Monroe County. Call our case, please, Mr. Clerk.
State of Tennessee versus J. William Edwards.
Okay. The arguments, 20 minutes aside. If you want to reserve a portion of that for rebuttal, make that announcement at the beginning. Okay, Mr. Harwell, you're underway.
May it please the court. My name is Jonathan Harwell. I'm a member of the Knoxville Bar here on behalf of Dr. J. Edwards, the defendant appellant in this matter. If I could reserve 4 minutes of my time for rebuttal.
Yes.
I have a number of issues that were set out in the brief. I plan to only discuss two of those issues, a suppression issue and a jury instruction issue. This was a case, the basic allegation was that after a dispute between Dr. Edwards and his wife, that he assaulted her and restrained her in their house over the course of an evening and night, and was ultimately charged with assault crimes and especially aggravated kidnapping. The basis of the motion to suppress related to an arrest warrant. Ultimately, at the end of this night, law enforcement obtained an arrest warrant for Dr. Edwards, forced their way into the house, arrested him, located a gun in the residence that was introduced into evidence, and also took some pictures that were used as evidence at trial. The basis of the motion to suppress had to do with the content of the affidavit submitted to obtain the arrest warrant. This event came to the light of law enforcement early in the morning when they received a call from, so the wife's name is Jelena Edwards. They received a call not from her, but from her sister, a woman named Maya Mandusic. Ms. Mandusic, I may just call her the sister, was in South Carolina. The sister calls law enforcement, reports that the wife had told her, the sister, that she had been assaulted, and that the wife had asked her, the sister, to call law enforcement. So the sister did. Law enforcement went out to the house. They did not observe anything out of the ordinary. They made a number of attempts to contact people inside the house, including calling the wife's phone. Eventually, the wife did answer. The officer indicated that she sounded a little upset, but said she was okay. Officers asked her to come outside. She declined to do so. Ultimately, as I said, they didn't see anything else that seemed out of the ordinary, and so they left. A couple of hours later, I think there's another call to law enforcement from the sister in South Carolina, saying at this point she has received some photographs that have been emailed to her by the wife. About 4 o'clock in the morning, a detective becomes involved. So instead of the patrol officers, there's now a detective involved. He gets information from the officers who had gone to the scene. He calls and talks to the sister in South Carolina. She gives him the update that she has. She provides him ultimately with the photographs that she said had been sent to her. At around 6 o'clock, 6:15 in the morning, there was a sort of confusing set of phone calls. So Detective Farrell, who's the detective, he is on the phone with the sister in South Carolina. The sister in South Carolina reports that the sister is in the same house with her mother, and that her mother is on the phone with the wife back in Knoxville. So mother and wife on the phone, sister and detective on the phone. Detective never talks to the wife. But in that sort of telephone game, the sister reports to the detective that the wife says that she is in the house, she is downstairs, defendant is upstairs. She is asking where she can go the next day to make a police report. Ultimately, she tells the mother that she is okay and she'll talk to the mother tomorrow. So that is the information available to Detective Farrell when he goes and gets an arrest warrant. As I said, that last phone call was about 6:15. He gets the arrest warrant after that. Officers have the scene under observation beginning at about 7 o'clock. At 8 o'clock, they ring the doorbell. No one comes to the door. They can't establish contact, so they force their way in. The challenge to the arrest warrant was essentially a Frank's challenge, or little under Tennessee law. And there's two parts of that. One, omissions, that two places during that course of events. First, when officers are on the phone briefly with the wife while they're outside, she told them she was okay. And two, when there's this four-way two-conversation interaction, the wife tells her mother that she is okay. Both of those facts were omitted from the affidavit submitted in support of a arrest warrant. So there's a Frank's issue relating to that. I think the more substantial Frank's issue is a false statements rather than omissions. And this relates really to the source of information that Detective Farrell has. He fills out his affidavit. Ultimately, at the suppression hearing, he agrees that he could have written it better. But I think it goes beyond being written poorly, because what he does in his affidavit is he details a number of direct accusations. He says victim was able to get to her phone and take pictures which showed swelling. Victim stated that the defendant, Jay Edwards, was the one that did this to her. She stated also that he hit her in her ribs and stomach area. All of those statements are presented just as I said them in the affidavit for the arrest warrant. What is not said, and what is not said at all, is that every bit of information that Detective Farrell has, he has only because the sister has told him that that's what the wife said. So this is written as if law enforcement has these allegations from the wife, when in fact these allegations are coming not from the wife, but from the sister saying this is what the wife said. And so our claim is that this is a misleading, recklessly misleading presentation of information known to law enforcement. Under Franks and Little, when you have misstatements of that nature, the solution is not to rewrite the affidavit. We don't get to go back and say, well, this is what he really meant. This would have added up to enough if he included the fact that the sister was telling him all of this. Because what you do under Franks is you eliminate those false statements. And if we rule out the false statements, the statements indicating that the wife has said this directly to law enforcement, if those are kicked out, there's nothing left in the affidavit. And so there would not be probable cause. The backup argument presented by the state, both on appeal and at the motion to suppress, was, well, even if the arrest warrant was invalid, there was exigent circumstances. And as we've addressed in our brief, in the reply brief, I don't think that has been shown. Exigent circumstances here, the state is traveling under the theory that there was an imminent risk of immediate harm to the wife at 8 o'clock when officers forced their way into the house. And I think there's a requirement of a strong showing to get an exigent circumstances exception that there is an immediate danger of injury rather than a prior injury or prior danger of injury. And here, the only information, or the latest information that law enforcement had from 6:15 that morning was that the wife was in one part of the house and the defendant was in another part of the house, and the wife is wondering what she can do the following day in order to make a police report. So from that information to draw the conclusion that there's no time to get a warrant, we have to immediately bust in to avoid the imminent harm, I think just doesn't follow. And in fact, it's clear that Detective Farrell didn't think that the harm was so imminent that he didn't have time to get an arrest warrant because he did go get an arrest warrant. It just, as it turned out, he went and got an invalid arrest warrant. So that's our suppression issue. I think it is important just to parse the language of the affidavit, which is set forth in the brief to see its misleading nature. The second issue I want to address is a jury instruction issue. This is a confusing issue. I've never seen anything quite like it. I'm not sure I did it justice in my brief. But this relates to the fact that the defendant was charged with especially aggravated kidnapping in 2 counts. He was charged in the 3rd count with just aggravated kidnapping. The legal basis for this claim is that especially aggravated kidnapping, you can do it 4 separate ways under the statute. And aggravated kidnapping, you can do 5 separate ways. The law provides, though, that when you're looking at what is a lesser included of especially aggravated kidnapping, not every form of aggravated kidnapping is a lesser included of especially aggravated kidnapping. So if you have especially aggravated kidnapping by means of serious bodily injury, then the lesser included of aggravated kidnapping has to be the aggravated kidnapping that relates to bodily injury. You can't go from serious bodily injury and then have as the lesser the form that involves display of a dangerous weapon. And so I think that's the case of Winton, that elements of the lesser offense have to be also elements of the greater offense. So the weirdness arrives in the actual jury instructions that were given by the court here. They were not objected to, but we're arguing a constructive amendment, in which case objection really is immaterial. So as the judge began his instructions, he gave what I believe to be correct instructions on the charged offense of especially aggravated kidnapping. He then said, if you find the defendant not guilty of especially aggravated kidnapping, you can go on to consider the lesser offense of aggravated kidnapping. At that point in the instructions, he did not provide the elements of aggravated kidnapping. He merely said, elements of aggravated kidnapping will be defined for you later in these instructions. So as I said, counts 1 and 2 are especially aggravated kidnapping. Count 3 was charged just as aggravated kidnapping. So when he finally gets to count 3, it is now time to provide the elements for aggravated kidnapping. So he said he was going to provide them later. He is now providing them in the context of count 3. He then says, defendant is charged in count 3 of the indictment with the offense of aggravated kidnapping. He's entered a plea of not guilty. Any person who commits the offense of aggravated kidnapping is guilty of a crime. Find the defendant guilty, the state must have proven the following essential elements. 1, knowingly confined another unlawfully, and 2, that the alleged victim suffered bodily injury. So we have what there appears to be a complete summary of elements of a crime. I'm going to talk about aggravated kidnapping. You have to prove these elements. Here are the 2 elements you have to prove. But then the very next sentence, and again, you will just have to read this probably to understand how sort of nonsensical it is. The very next sentence is he now provides another description of the elements. So he said, here's the 2 elements. And then he says, for you to find the defendant guilty of the offenses charged in count 3, the state must have proven beyond the reasonable doubt the existence of the following essential elements. Knowingly confined, and now a different second element. The defendant possessed or threatened the use of a different weapon, of a deadly weapon. So in the course of that one set of instructions, we have 2 separate lists of what the elements are, and they're different. The first element is the same, but the second element is not the same. And ultimately, that is not there's no logical way to reconcile that. We have been given two inconsistent descriptions of what the crime of aggravated kidnapping is. They came one right after another. There is no explanation as that this portion relates to one count and this portion relates to another count. It is just thrown out there, two inconsistent descriptions of the crime. I think I said this. This matters because ultimately the defendant is not convicted of the greater offense of especially aggravated kidnapping. He is convicted only of the lesser offense of aggravated kidnapping. So it is the offense that has these inconsistent descriptions of the elements that he is convicted of 3 times. I've explained, I think, 2 separate arguments as to the legal consequences for this problem. The first is that there is a constructive amendment problem. Count 1 as charged could only have as a valid lesser included aggravated kidnapping accomplished with a dangerous weapon. But because of these 2 sets of instructions, the jury could also have convicted him based on bodily injury. Count 2 has sort of the opposite problem. As charged, count 2 only had the valid lesser included of aggravated kidnapping by bodily injury, but instead the instruction would have allowed a conviction based on possession of a dangerous weapon. And the other way to look at this problem is you have a unanimity problem, that under these instructions, some jurors may have looked at the first part and said, well, we can get there by confinement plus bodily injury. Other jurors may have looked at the second part and said we can get there by confinement plus use of a deadly weapon. Both of those parts were disputed. There was disputed proof as to whether there was any confinement, and there was disputed proof as to whether she was injured in any way. She testified she was confined. She testified she was seriously injured. Obviously, the jury had a problem with some of that because it didn't find her guilty of the greater offense. So I will, if there's no questions at this time, I'll reserve the rest of my time for rebuttal.
Thank you. General.
Good afternoon, Your Honors. May it please the court, Orr on behalf of the state. I will just take the issues in the same order that the defendant has addressed them here today, starting first with the arrest warrant. Before getting into whether there were material omissions or misstatements, which we disagree with the defendant's theory, I would be remiss if I did not point out that the defendant relies heavily on Little and its progeny to say that the arrest warrant was invalid for allegedly misleading statements or material omissions. However, this court has twice expressed doubt about whether Little's search warrant analysis applies with equal force to arrest warrants. That was in State versus Pierce in 2015 and State versus Johnson in 1989. The defendant has not cited any Tennessee case law which would suggest that Little analysis applies with equal force to arrest warrants, and I have not been able to find any controlling case law. Although I will note that both Pierce and Johnson, which are these Tennessee prior case laws, are both unpublished and merely persuasive to this court. But even assuming Little were to apply equally to arrest warrants, Detective Farrell's statements within the affidavit were accurate and provided sufficient probable cause to support the arrest warrant in this case. Here, there was not a material omission because Detective Farrell did not include allegations that the victim told officers and her mother, quote, "I am okay." Officers told that to Detective Farrell, and Detective Farrell learned that from Miss Manjusic, but in both instances, he had reason, and from the officers, she told him, she says she's okay, but we hear whispering in the background. From Miss Manjusic, he learned she said she was okay to her mother, but her voice sounds strained and she seems upset. Simply put, not including the phrase, "I am okay" in the affidavit did not amount to a material omission. Here, the officer was not required to essentially conduct a cross-examination of the evidence within the body of the affidavit. Instead, he was able to rely on his experience investigating domestic violence cases to include that the officers had made contact with the victim and heard a voice coaching her on the other end of the phone. This was not a material omission for the purposes of the arrest warrant. Next, the arrest warrant does not imply that there was a direct line of communication between Mrs. Edwards and the officers. And I apologize to reading to the court, but the applicable language regarding this issue was that the victim was able to get to her phone and take pictures which showed redness and swelling on her both cheeks and a bloody lip. The victim then stated for her sister to call the cops because she, quote, had the shit beat out of her. I apologize for the language. She stated he also hit her in the ribs and stomach area. Victim stated she was scared and she wanted her to call the cops. Reading the plain language of this affidavit, it was clear that the officers were getting this information from the victim's sister, who the victim had called and asked to contact the cops. There's no implication that the officer or that Detective Farrell had a direct line of communication with Mrs. Edwards.
Miss, let me ask you about the last discussion you had or statement you had about what the sister said.
Yes.
Was that after the first call from the wife to her sister that led to the two officers going out that morning, or was that a later call?
There's ongoing communication between Miss Mandzuzic and various officers throughout the evening. She first was able to speak to the two patrol officers, and she sent them the photos that Miss Edwards had sent her. She later, I believe it was around 4 a.m., spoke with Detective Farrell. She sent the same photos to Detective Farrell. She read some text messages that were sent from Mrs. Edwards to Detective Farrell. And she also had this, as Mr. Harwell has described, it's kind of like a four-way phone call between Mrs. Edwards and her mother and Miss Mandzuzic and Detective Farrell.
All right, and one more question. The way I understood the facts were that, and maybe I misunderstand how this came about, but that the two officers that were trying to get the wife to come to the door were the ones that heard the whispering in the background. Is that incorrect? Or?
No, that is correct, Your Honor.
Okay, that's correct. Okay.
Simply put, though, Detective Farrell was entitled to rely on the information from Miss Mandzuzic. The police can rely on information from known informants when completing an affidavit. They're also allowed to rely on information from the other officers investigating the case. The affidavit in this case has a mixture of those two things: information regarding from other officers in their investigation, and then information provided by a known citizen who was calling the cops to help her sister. In short, there was no material omissions and no misleading statements, and the trial court correctly found that this arrest warrant was valid. Even if this court were to find that the warrant was invalid, exigent circumstances also justified entry into the home. As noted earlier, the police had maintained an indirect line of communication with Mrs. Edwards throughout the evening, from 2 a.m. till about 6:30 a.m. They knew the defendant had a gun in the house, and they knew Mrs. Edwards feared that he would retaliate if she discovered that he was communicating with the police. She said this multiple times over and over and over again to her sister. That was relayed to Detective Farrell, and that was also relayed in that four-way phone call. When officers arrived, they made several attempts to contact Mrs. Edwards by knocking on the door and calling her phone, but they were not able to get in touch with her when they were at the house. After they received no answer from a previously open line of communication, they became concerned about her welfare because they had reason to believe that their presence at the home would have triggered the defendant to cause further harm to Ms. Edwards. Based on the totality of the circumstances, there were exigent circumstances for them to enter the home. But even aside from any exigent circumstances, one thing I believe the defendant has not addressed here today is that any exclusion of evidence or evidence that was collected during execution of this arrest warrant, inclusion of evidence at trial would have been harmless error. The only evidence collected from the house was the physical gun and photos that the police took of Mrs. Edwards at that time. Mrs. Edwards, however, testified that the defendant held a gun to her head, that he threatened multiple times to shoot her if she called the cops, and that he had a gun with him throughout the evening or throughout the night as he prevented her from leaving. She also testified that because of his gun, she did not feel that she could safely leave the house with her child until the police arrived at 8 a.m. Further, she testified in detail about her injuries and additional photos that Ms. Edwards took herself and sent to police a day or two after the offense were also admitted at trial. So in light of all of the evidence submitted at trial, any evidence that was collected during execution of the arrest warrant was harmless. Next, I will address the jury instructions issue, but I want to start with addressing the correct standard of review here as it regards to the constructive amendment claim. The defendant argues that this is an automatically reversible error, relying on this court's recent opinion in State versus Warren Smith. However, that is simply incorrect. The correct standard of review here is plain error because the defendant did not object to the instruction at trial. Warren Smith, after that opinion was released, the state filed a petition to rehear, addressing specifically the jury instruction claim examined in Warren Smith. In the order denying the petition to rehear, this court very clearly stated that when there is no objection to a jury instruction on a constructive amendment claim, the applicable standard of review is plain error, and the defendant still bears the burden of showing plain error. I realize neither party has cited the order denying the petition to rehear in their briefs, and I'm happy to submit this as a letter of supplemental authority to the court. But here, the applicable standard of review is plain error. And there is no clear and unequivocal rule of law broken in this case. When read as a whole, the jury instructions accurately define the offenses in the indictment and accurately charge the correct elements. Starting with count 3, the instructions, although I will agree with the defendant, they are not as clearly written as they can be. The instruction, when read, says in count 3, the defendant is charged with aggravated kidnapping. This offense is defined as, and it defines, I believe, the bodily injury elements. Then in the second half, the instruction says to find the defendant guilty as charged in count 3, and it gives the correct instruction as it is charged in count 3. The jury very clearly would have understood that count 3 was the second half of that instruction, and that was the correct elements charged in this case. Regarding counts 1 and 2, the indictment included jury instructions, and it clearly noted, the indictment was included within the jury instructions, and the indictment set out the charged offense or the charged theory in counts 1 and 2. The instructions also told the jury that aggravated kidnapping as a lesser included offense for count 1 and 2 would be defined later. The later instruction for aggravated kidnapping included the applicable theories for the lesser included offense, the correct applicable theories. This is not a case where the offense defined in the lesser included offenses included elements that were not the correct lessers of counts 1 and 2. Instead, the elements as charged in count 3 were the correct lessers for counts 1 and 2. The defendant's argument simply amounts to the fact the jury may have been confused based on the word.
General, let me ask you a question here. This court has had the opportunity more than once in recent sessions to remonstrate with prosecutors who allege lesser included offenses in separate counts from principal offenses.
Yes.
Is that some teaching that prosecutors are getting from someplace? It seems to be a recent development, and it's causing some problems. And Knox County is a leading offender in this type of indictment. Why charge a lesser included offense as a separate count under a count alleging a principal offense? It's automatically charged in the indictment, and there's no need to complicate the matter for the trial court by charging it as a separate offense. You want to elaborate on that practice at all?
I wish that I could elaborate a little bit more on this practice, for Your Honor. Unfortunately, we do not know the training that the DAs undergo, and we are not privy to their charging decisions. And silent as to the motivation for these charging decisions.
Well, I can understand why you would avoid any culpability for what's been going on, but this is not probably not the most serious example of what I'm talking about, but we have, as I said, remonstrated fairly explicitly in a couple of opinions that that's a practice that ought to stop. And I'll just leave it at that.
I understand Your Honor's points. Unfortunately, I can only deal with the facts that are presented to me in any given case. And here, the record is silent as to the motivation behind the charging decisions. And the only issue raised is as a constructive amendment or a jury unanimity problem. Here, we submit that there is no constructive amendment problem simply because when read as a whole, the jury could identify the applicable elements for counts 1 and 2, and then identify the correct theory as it is laid out within this jury instruction as it applied to each offense. Therefore, there is no constructive amendment problem, and the defendant cannot show that there was a clear and unequivocal rule of law that was broken. Moreover, there is no jury unanimity problem because, as I noted here, the jury could correctly identify the applicable theory of liability for each charged offense. And this is not the classic jury unanimity case where you have, I believe the example I always go to is a child rape case where there may be 3 charges of child rape, but the victim testifies to 5. And there you have to do an election to make sure that the correct set of facts applies to each charge. Here, there's one set of facts. There's no debate as to whether the jury is deliberating over the same course of criminal conduct. Because there's one set of facts, because the jury could correctly identify the applicable elements, there is no jury unanimity problem here. Unless this court has any further questions, we ask that you affirm, we stand on our brief for the remaining issues, and we ask that you affirm the judgment of the trial court.
All right, thank you. Rebuttal.
Just briefly, Your Honors, I think to begin with the jury instruction issue, as the state, I think the state's position this afternoon, as Ms. Orr read through those instructions, the state's position was that the jury would have known to only use the second half of those instructions and to disregard the first half of the instructions. In its brief, the state referred to some of that language as surplusage. In its brief, and again in argument, the state has suggested that to the extent there were inconsistent enumerations of the elements, well, the jury had the indictment charging the greater offense, but the jury could somehow have worked back from the indictment to figure out which of these inconsistent instructions actually applied. And I think when we start talking in that way, we have lost the point of jury instructions. Jury instructions are supposed to tell the jury what to do. They're not open to interpretation. They don't require jurors to have legal knowledge to make decisions of what a proper or lesser included instruction is. It doesn't make them, it put them in the position of deciding what is important and what is surplusage. When I was a kid, we had these books, choose your own adventure books, where you'd read a page and decide where you wanted to go next. Jury instructions are not supposed to be choose your own adventures. They are supposed to set out clearly and accurately exactly what the law is. And we cannot put a jury in a position where it's guessing what the law is, where it is trying to engage in interpretations to come up with what the law is. Here, these instructions read on their face are facially inconsistent and invalid, and the conviction that resulted simply cannot stand. There certainly has been a debate as to whether a constructive amendment is an automatic reversal or goes through plain error. I think ultimately it doesn't matter because the cases applying plain error, it is plain error. The prongs of plain error will almost always be met and are met here. So whether you call it automatic reversal, whether you call it plain error that always results in reversal, I don't think really matters. To talk about the significance of the gun, I would just point out, I don't know how you claim that the gun, introduction of the physical evidence of the gun can be harmless in a case where the defendant was ultimately convicted, possibly, depending on how you interpret the instructions, but possibly of crimes involving the use or display of a deadly weapon. It certainly was disputed at trial whether a gun was displayed. The wife claimed that a security video should show a gun, but the security video did not seem to show the gun. So whether there was any gun at all in the house was disputed, and the fact that the state was able to corroborate the wife's testimony to some extent by bringing in a physical gun, I don't think can be deemed harmless. Very quickly, finally, just to get back to the affidavit, I think the last statement in the affidavit was, victim's injuries are consistent with her statement. The truth of the matter was that Detective Farrell was saying that the victim's injuries, as described to him by the sister, were consistent with the photos that were provided to him by the sister. If you understand the truthful context, that becomes meaningless. Yet that is presented in the affidavit as a fact, essentially indicating Detective Farrell's conclusion that this claim has been corroborated. I believe I've used my time. If there's no other questions, we'll rely on my briefs.
All right, thank you. Thank you. That concludes the argument in this case. Court will take a recess and reconvene at 3 o'clock.
Recess until 3 p.m.